If you are seeking custody of your child, it is important to file your claim with the correct court. A court may only hear your case if it has proper jurisdiction. Jurisdiction is the official power of the court to make legal decisions and judgments and is typically governed by state law. The Uniform Child Custody Jurisdiction and Enforcement Act. For many years, it was difficult to determine which court had child custody jurisdiction. American families became increasingly mobile, often moving from state to state. Under those circumstances, determining which state law governed a child custody dispute was confusing. Different state laws and years of court decisions created conflicts between states and, in some cases, federal law. Home state jurisdiction for an initial child custody determination is governed by Connecticut General Statutes 46B 115K. The law sets forth 4 bases for jurisdiction, with each succeeding basis only applying if no state meets any of the previous bases. The first basis is commonly referred to as home state jurisdiction. The law provides that a court of this state has jurisdiction to make an initial child custody determination if this state, 1, is the home state of the child at the time of the commencement of the proceeding, or, 2, had been the child's home state within 6 months before the commencement of the proceeding, the child is absent from the state, and a parent or person acting as a parent continues to live in this state. Significant connections jurisdiction. There are circumstances, however, when a child has no home state, or no one remains in the home state. For such cases, the law provides a second basis that is generally referred to as significant connection jurisdiction. Under this basis, Connecticut has jurisdiction to make an initial child custody determination if no other state has home state jurisdiction, or if the home state has declined to exercise jurisdiction on the ground that Connecticut is a more appropriate forum, and the child and at least one parent or person acting as a parent have a significant connection with this state other than mere physical presence, and there is available in this state substantial evidence concerning the child's care, protection, training, and personal relationships. If 2 or more states meet these criteria, priority among potential jurisdictions is resolved in favor of the first filed proceeding. More appropriate forum jurisdiction circumstances may arise where Connecticut may be a more appropriate forum than the state that has home state jurisdiction or significant connection jurisdiction. For such situations, the law provides a third basis for more appropriate forum jurisdiction. Under this basis, Connecticut has jurisdiction to make an initial child custody determination if the state that would have home state jurisdiction declines to act on the ground that Connecticut is a more appropriate forum, and the child and at least one parent or person acting as a parent have a significant connection with this state other than mere physical presence, and there is available in this state substantial evidence concerning the child's care, protection, training, and personal relationships. It is important to note that it is the home state that must make the initial determination that Connecticut is the more appropriate forum. Connecticut may not draw that conclusion if the home state has not done so. Last resort jurisdiction. Finally, Connecticut has jurisdiction to make an initial child custody determination where no court of any other state has home state or significant connection jurisdiction and no court with jurisdiction has deferred to another state as a more appropriate forum. This is a last resort type provision, which should be used only when a child has no home state and no significant connection with another state. Since the applicability of last resort jurisdiction is so limited, it is infrequently used. Nonetheless, one example where last resort jurisdiction may apply is when a family has moved around so frequently that the children have never lived anywhere for 6 months, and as a result, have never had an opportunity to develop significant connections in any one state. Temporary emergency jurisdiction. In emergency cases, the UCCJEA provides a separate ground for exercising temporary jurisdiction. Under Connecticut General Statutes Section 46B 115N, a court of this state has temporary emergency jurisdiction to make a child custody determination by initial or modification decree if the following conditions exist. The child is physically present in the state, and either 1. The child has been abandoned, or 2. It is necessary in an emergency to protect the child because the child, a sibling or parent, has been, or is under a threat of being, abused or mistreated. Declining jurisdiction. The various jurisdictional bases previously discussed do not impose on the court a mandatory duty to act in all cases over which it has jurisdiction. Even if Connecticut, or another state, has jurisdiction to issue a custody order, it is not required to do so. The UCCJEA provides that a court may decline to exercise its jurisdiction at any time if it finds that it is an inconvenient forum to make a custody determination under the circumstances of the case, and finds that a court of another state is a more appropriate forum. The issue of inconvenient forum may be raised upon a motion of a party, the court's own motion, or a request of another court. CGS. Section 46B 115Q. Jurisdiction can also be refused if Connecticut obtained jurisdiction, because a person seeking to invoke its jurisdiction has engaged in unjustifiable conduct. See CGS Section 46B 115R. An example of unjustifiable conduct is where a parent has improperly removed, retained, or concealed a child in the state for the purpose of obtaining jurisdiction. Modification and continuing exclusive jurisdiction. The UCCJEA provides for exclusive, continuing jurisdiction. Once a Connecticut court has made a child custody determination pursuant to the home state, significant connections, more appropriate forum, or last resort jurisdictional provisions of the UCCJEA, it retains jurisdiction over the determination until a court of this state or a court of another state determines that the child's parents and any person acting as a parent do not presently reside in this state, or a court of this state determines that this state is not the home state of the child. A parent or a person acting as a parent continues to reside in this state, but the child no longer has a significant relationship with such parent or person, and 5. Substantial evidence is no longer available in this state concerning the child's care, protection, training and personal relationships. See CGS Section 46B 115L(a). Similarly, before a Connecticut court can modify another state's custody order, it should refer to the other state's version of the UCCJEA to determine whether modification jurisdiction remains there. If it does, the Connecticut claim should be dismissed. Jurisdiction issues concerning child custody can be difficult and confusing. At McConnell Family Law Group, our family lawyers can help resolve these issues and make sure your custody claim is filed in the correct court. For more information on how we can help you with your child custody claim, please contact us at 860-266-1166, and you may visit us at 638 Prospect Avenue, Hartford, Connecticut, 06105, United States.